Garner, is James Garner here?
I'm here.
Right from the start, the tone feels off. Walking into court wearing a hat and casual attitude signals a lack of awareness about courtroom decorum. The judge's simple request isn't just about appearance. It's about respect for the institution. Instead of adapting, Garner subtly resists, setting the stage for friction. This moment shows how small defiance early on can snowball into much bigger consequences later.
Good morning.
What is your middle name? Can you remove your hat, please? And your scarf. What is your middle name, Mr. Garner?
Errol.
Earl?
No.
He's on the 1:30 docket, Your Honor, I believe.
James Garner. Earl Garner. James E-R-R-O-L Garner, right?
Yes.
You are on the 1:30 docket.
If you want, Your Honor, I can give House Counsel an offer right now. She can report it to him.
On James Garner, do you see all the cases he has?
I see just the 4 that are on the docket. Or 5.
Yes.
You've got more?
He's got plenty more.
Okay. You want me to come down, review, and do a global offer?
If you could, please.
Okay, I'm on my way down.
Mr. Garner, do you want to offer on these or do you want to go to trial?
I would like to know what the charges are.
As the charges begin piling up, the situation quickly becomes serious. What seemed like minor infractions actually form a pattern of repeated violations. The judge is methodically laying out the reality, while Garner appears disconnected from the gravity of it all. This disconnect is critical. Underestimating legal trouble often leads people to make even worse decisions as pressure builds.
James Earl Garner, case number SP110045, counts 1, 2, and 3. SP11695. Those are driving license expired, misdemeanor, no insurance, insurance misdemeanor. Thank you. And an improper plate misdemeanor, all of them punishable by maximum possible penalty of 93 days in jail and or $500 in fines. SP 1169507, counts 1 and counts 2, expired license and no insurance misdemeanor, both punishable by 93 days in jail and or $500 in fines. SP 1169521, same improper plates, same punishment, $500 in 93 days in jail and or $500 in fines, maximum possible penalty. SP 1223079, driver one license suspended. SP 1273761, SP 1927512. 3 of those tickets are all punishable by 93 days in jail and or $500 in fines. SP 1547006, counts 1, counts 2, and counts 3. Those are civil infractions. SP 1547407, counts 1 and counts 2. Count 1 being a driver more license suspended repeat offender. This one is in warrant status, probably an old case that he didn't pay. SP 800104, counts 1 and counts 2. 1 being an unregistered untitled, he owes $1,194 on that. And SP and count 2 of that is a drug while license improper. It looks like he has a $114 fine on that. State of Michigan versus James Earl Garner, case number SX 362685661. that is a drove-while license expired. And that will be $500 maximum possible penalty, 93 days.
Here comes the turning point. Garner claims he doesn't even know the charges. That might sound strategic, but it actually weakens his position. The court has already documented everything clearly. This isn't confusion, it's avoidance. When someone refuses to engage with facts, they lose control of the narrative, and the courtroom is the worst place to do that.
Sherika Harris on behalf of Mr. Garner. Mr. Garner, please state your name for the record.
First off, I do have a couple.
You got to state your name first. You got to state your name first.
No,
Let's start there.
I think, wait a minute, Ms. Harris. Wait a minute, Ms. Harris. I think Mr. Garner is going to represent himself. Am I correct, Mr. Garner?
I'm representing myself in what?
The judge continues outlining the charges in detail, and the list just keeps growing. This isn't a single mistake. It's a history of noncompliance. At this stage, most defendants would start thinking about damage control. Garner, however, seems to double down mentally, preparing to argue principles instead of addressing consequences. That choice becomes increasingly costly.
About what's actually going on. First off, who's alleging these charges? That's what I'm curious about.
State of Michigan, City of Detroit.
Okay, well, if that's the case, there's a common law principle which states that for there to be a crime, there must be a victim. Corpus delicti. The state cannot be the injured party. And in the absence of a victim, there can be no crime.
We want to do it.
Drawing my name from the record on that one. Thank you.
I know. How do you want to proceed, Mr. Garner? You set the matter. I'll enter a not guilty plea on his behalf. Give him a $0 bond. Either set the matter for trial, or I'll wait for the city to give you an offer. What do you want to do?
Well, the court haven't even established jurisdiction. I mean, in order for jurisdiction, the jurisdiction has to be established first, and there's no jurisdiction established. And once jurisdiction is challenged, that must be settled.
Now we see the full scope, over a dozen charges. The irony is powerful. Despite facing serious penalties, the real danger isn't the charges themselves, but how Garner chooses to respond. Courts often allow room for cooperation, but that window narrows quickly when someone refuses to engage realistically. This is where outcomes start being shaped.
You want to put that in a motion, sir?
As far as I'm concerned, any and all charges must be dismissed because there is no complaining witness. And the state cannot be.
I'm not gonna listen. If that's your motion, I'm gonna deny the motion. Okay? So, all we're gonna do now, we're not gonna keep going back and forth. Either you take an offer or you set the matter for trial. Which one do you want?
Respectfully, in order for this to continue, there must be a complaining witness, and the state cannot be a complaining witness. Now, if I'm entitled to a fair trial, the law states there must be a victim. I'm just requesting, who is the victim? Who did I injure?
The citizens of the city of Detroit and the state of Michigan are the victims.
The state cannot be a victim. And if that's the case,
I said the citizens of the city of Detroit and the state of Michigan are the victims.
if that's the case,
Mr. Garner, can we just go into a breakout room and then maybe I can give you a little bit of advice to assist you with moving forward? Would you be agreeable to that?
Sure.
Garner decides to represent himself, and the reaction says everything. Self-representation isn't inherently bad, but it requires deep legal understanding. Here, it's clear he's relying on misunderstood legal concepts rather than actual law. Confidence without competence becomes a liability, especially in a courtroom where precision matters more than belief.
What do you want to do, Mr. Garner? Do you want a trial date or you want an offer? Those are really your only two options.
Okay, since we are on the record, all I'm asking for Is the
Okay, one last time. Now listen, here's how it's gonna go from this point on. If you don't answer the question that I asked specifically, then I'm gonna hold you in contempt of court, and we're gonna move from that point on.
The no victim, no crime argument enters, a classic but flawed approach. It sounds logical on the surface, but it ignores how laws actually work. Many offenses are against public order, not individuals. The judge doesn't entertain it, signaling that this line of reasoning won't succeed. Garner, however, keeps pushing, missing the cue to pivot.
the court is just going to
We're not gonna
violate
have a
the
conversation.
law.
Stop, sir. Stop, sir. Now, that's the last time I'm gonna ask you to.
On the law. Is that what I'm hearing?
All right.
I'm asking.
I'm gonna hold Mr. Garner in contempt of court. He is directly violating the court's order. I've asked him repeatedly to not interfere or add any extra commentary to this case. I've given him ample time to answer the court's question, and he continues to refuse to do so. So now I'm gonna hold you in contempt, and I'm gonna sentence you to 30 days Wayne County Jail. No early release.
So that means that the court is just going to violate my rights because I'm defending myself? Is that what I'm hearing?
30 days, Wayne County Jail. No early release. That'll give you some chance and some time to read up on your rights, okay? Fill out the contempt papers, Madam. So I'm gonna order you to turn yourself in today, Mr. Garner, to start that jail time, okay?
So I have a question.
I'm not answering any more of your questions. Turn yourself in to the Wayne County Jail today.
So the court is going to be in direct violation of my rights in the law. Is that where we're standing?
If that's how you feel. Have a good day, sir.
The judge offers clear options: take a deal or go to trial. It's straightforward, but Garner keeps circling back to jurisdiction arguments. This is where things unravel. Courts operate on structure, and refusing to follow that structure doesn't stop proceedings. It just isolates the defendant. The gap between reality and his approach widens rapidly here.